So let's get started. Welcome, everyone. It is great to have you all here at this 4IP Council's webinar entitled Innovating in IoT and Standards, how SMEs can navigate standards development, patent licensing, disputes, and IP strategy. My name is Axel Frazzini. I'm the Managing Director of 4IP Council, and I will be your host today. So as you may be aware, 4IP Council is a not-for-profit research organization. We are dedicated to exploring the relationship between IP and innovation. And our aim is to identify the most relevant topics and to conduct empirical research through collaboration with a variety of academics, experts, IP organizations, and other stakeholders. So on our website, you can find a lot of free materials. I mean, everything is very transparent, accessible, and you can find, for example, summaries of relevant papers, guides, and studies. We also upload the recordings of our webinars, like the one that you are attending today. And we have a podcast called IP Stories. We also produce easy to digest content such as the SMEs Corner, especially tailored for non-IP experts. And I would also like to invite you to the area on our website that is called IoT and Cellular Standards Made Simple, which is very relevant for today's webinar, where you can learn a lot about the benefits of standardization, standards, and the IoT across different sectors. We have launched a new area called AI and intellectual property rights, so AI and IPR, with guides, videos, papers, and interviews to help you understand how AI is transforming the way we live, work, and create, but also addressing the pressing questions raised about intellectual property rights. But without further delay, it is my pleasure to introduce our speakers for today's webinar, Dr. Matteo Sabattini, Jamie Lewis, and Justine Ferland. And by order of presentation, I will start with Jamie, who has been with the UK Intellectual Property Office for almost 12 years, specializing in a number of areas of IP law and policy, including international trademarks, designs and brands policy, copyright, and more recently, standardization patents and IP and competition policy. Then Matteo has years of expertise in technology licensing and IP strategy. He currently serves as executive head of government affairs at Sisvel, Europe's largest and longest established patent pool operator. And finally, we have Justine, who is a legal officer in the External Relations and Planning section at the WIPO Arbitration and Mediation Center. Before joining WIPO in 2021, Justine practiced as a civil and commercial litigation attorney at Fasken in Montreal and as a researcher in art and IP law at the University of Geneva. Final remark, please use the Q&A tool that you can find at the bottom of your screen to ask your questions live, and we will take all the questions right after the presentations. And I know that we will receive again and again this question. Yes, the webinar is recorded and the recording will be made available tomorrow. So without further ado, Jamie, the floor is yours.
Thank you so much, Axel. Thank you for the overview of today's webinar. It's an absolute pleasure to be here today to talk on this important matter. What I'd like to do is take a few moments of your time to talk through some of the UK government's strategy for supporting SMEs innovating in IoT and the role of intellectual property. The UK government's mission is to create and accelerate innovation, investment and productivity through world-class science and development. That mission informs our own IPO strategy to help the economy and develop an IP system that encourages investment in innovation and creativity. This in turn underpins the government's work on standard essential patents and the review of the SEPS ecosystem. It's also relevant to the work of the government's objectives to to boost productivity and growth in small businesses and building more secure, resilient and innovative telecoms supply chains and IoT. So SEPs are of growing importance. So our standard essential patents, I should say, are of growing importance to technological innovation and to the UK economy. They're building blocks of our connected future, enabling our devices to communicate seamlessly, from smartphones to those electric vehicles, smart manufacturing to innovations in healthcare. They help deliver real technological change for people. Domestically, the numbers of UK businesses in the Internet of Things sector has more than doubled in the last decade, the majority of whom are SMEs. This trend is set to continue. Emerging industries that rely on technical standards are expected to grow at a faster rate than the UK economy as a whole. This growth will continue to be driven by high demand for interconnected devices, including smart home technologies in the UK consumer market. The government's digital and technology sector plan, part of our industrial strategy, identifies advanced connectivity technologies as one of the 6 areas that has the greatest potential to stimulate technology-enabled growth over the next decade. The importance of SEPs and technical standards are there to sort of increase the use of SEPs across industries, and the UK is therefore expected to grow. The number of patents declared as essential worldwide is growing increasingly. STOs like the European Telecommunication Standards Institute, ETSI, publishes thousands of new standards every year, and there are important standards to develop in these areas, including 6G technologies. What I'll do now on the next slide, I will spend a little bit of time talking you through really the focus of today's presentation about what support the IPO offers for SMEs innovating in IoT and standards. So I'm going to sort of work my way around the slide deck just to sort of outline the sort of areas of support we provide, and I will signpost those who are participating today to those areas of support. So the slide you can see in front of you will summarize really the practical support that we provide to SMEs. It's structured around 4 common pinch points. Those include navigating standards development, licensing, included SEPs and FRAND, dispute resolution and case law, and broader IP strategy and capability building. Alongside that, I'll signpost to online guidance and training tools that SMEs can access directly. So zooming in a little bit further into the first, on the top left of the slide, which you can see the navigating standard development. For SMEs, the first challenge is often simply getting oriented into the standards landscape. So what standards are, how standardization works, and who the relevant standards bodies are. The IPO's SEP Resource Hub, which is sort of our central repository of information to help users guide this landscape, includes a dedicated section on technical standards and standard development organizations. And it's designed as a one-stop collection of guidance and signposting to help UK businesses navigate that ecosystem. We describe this as step 1 of the SEP licensing journey. So when you look at navigating standard development, that's what we see as the main sort of area which you should focus on in the first instance. And that's starting with development of technical standards, why they matter for interoperability, and provide basic information on SDOs. For an SME working in the IoT, it will help them identify quickly where standards are set and how to engage appropriately in that standardization. Moving on to the sort of next area in the on the slide here, I talk about sort of patent licensing, including SEPs and FRAND. In this second area, SMEs can face a real complexity and information gaps. So our approach at the IPO is really driven by 3 objectives here. And that is firstly to help implementers, especially SMEs, navigate and understand the ecosystem around FRAND licensing. Secondly, to improve the transparency in pricing and essentiality, and to improve then finally the efficiency in dispute resolution. And the SEP resource hub really sort of is focused on those areas, and it includes a dedicated section on standard central patent licensing. And we do so because we recognize that SEP licensing as a potentially daunting for those new to licensing of SEPs, but also our guidance covers the licensing journey from the entry point to the exit point, and includes licensing models and SEP-specific aspects of IP licensing. The IPO, through its recent consultation process, has also been provided with a useful evidence base around how IoT licensing can sometimes create uncertainty and preparedness, and how that can impact in business activities, particularly when faced with unexpected licensing fees, and how to respond to licensing demands that can lead to costly litigation. So this is exactly why the structured information in the resource hub around how to think about it. Materials really do help, and it often can be used by SMEs to decide whether and when to speak to professional advice. And then moving on to sort of dispute resolution and case law. And this third area of support is really focused on when negotiations don't run smoothly. SMEs need to understand their options, including alternative dispute resolution, and what remedies typically a court can consider in these sorts of disputes. So the resource hub includes a section on dispute resolution and remedies, and this section of the guidance recognises that disputes may arise and can potentially be mitigated or resolved through using existing dispute resolution services. And we provide further details on those services and remedies typically sought out and intercept disputes. And importantly, the hub also provides additional resources around case law. You can look at the case law and look at actually is there any precedent to a typical case which you're dealing with, or whether you have a similar sort of issue which you're licensing around. It also provides sort of glossary of the common terms which are used in SEP licensing. And we also provide, which is right for the UK in terms of domestic level, we provide a signpost into international options as well, because it's really important that we recognise it's a global landscape. So SMEs really through this aspect of the resource hub can find the right information, the context and terminology quite easily and quickly. And then finally, we offer support at the IPO in relation to IP strategy for IoT innovators. And I wrap around to these practical SEP and standards journey aspects with some details around the broader strategy and capability building opportunities which we provide for businesses. Specifically on the government web pages, we have business tools and training that sets out guidance for IP and business online tools designed to help businesses navigate and understand how IP works, manage and use IP, but also incorporate IP into business planning. There is a guidance specifically that lists tools including IP Equip. So we have e-learning modules, IP health check modules as well. These can generate tailored reports and action points for innovators. We also provide business-to-business toolkits for collaboration. And in parallel to this, IPO Online Support Tools portal explains how the tools are free and for businesses to use and others. And it's really, these tools are separate to the rights granting services we provide as an IPO, but really are important and quite frequently used. We have a significant volume of use of these tools. In terms of training, which we provide, and this is another vital area of support which the IPO provides, we host the intellectual property training. It's a collection of one-day CPD accredited workshops and a two-day in-depth masterclass course aimed at business users. We deliver bespoke webinars, workshops, and provide one-to-one guidance. And we've created a one-day IP workshop for SMEs, which brings about the basics of IP to life and provides relatable case studies. We also have a number of areas supports at the IPO, including an IP audit funding, and that is where we provide a scheme which part funds. We've closed the funding for this year. There may be additional funding in the new financial year, just to say that point as well. But we do provide part funding for effectively what is a audit, and it's a bespoke boutique sort of audit which is undertaken. That includes exposure or use of technical standards, cost projections, etc. And it's a really, really helpful tool. I understand from feedback from users of that. For the UK as well, we also provide a set of regional policy advisors, and we provide information IP through patent libraries, or patent libs they're called, and business centres across the UK, as well as longer term IP skills development. So to conclude, really, the support of the IPO in the UK for IoT innovators, especially SMEs in that space, our support is really offered incrementally. You can start with the SEP's Resource Hub for standards and SEP front issues and licensing challenges, but also how to find more information, how to resolve your disputes. You can then use our IP for business tools and training to build your capability and embed in IP into your thinking around your product and commercial strategies, particularly important for IoT business working in standard-driven markets. And that's my update for you.
Okay.
Matteo, you can go on.
Yes, I'm next. So yeah, thanks, Jamie. And thanks for IP for inviting me, for having me here. You said already quite a bit about me, but let me tell you a little bit about Sisvel very briefly. Sisvel was founded in 1982 in the outskirts of Torino, Italy, and has grown to become a leader in the management and formation of patent pools. Patent pools are an efficient and pro-competitive industry solution that provides efficiencies and transparency to the ecosystem. In particular, at Sisvel, we focus and we strive to provide as much transparency as we can. We believe that transparency can help the ecosystem to function. And in fact, if you go on our website, you'll see a lot of information about our programs. You'll see the royalty rates, you'll see a list of patents, you often see the agreements themselves so that they can be printed out and signed. One thing that not many people know about Sisvel is the fact that we also have a small R&D team called Sisvel Technology. Sisvel Technology has helped Sisvel to navigate the always evolving landscape for standardization. We do participate to some standardization activities. We do create our own technologies, and we own our own patents. So through Sisvel Technology and through some acquisition, we've grown our own patent footprint. This is something to keep in mind as we talk about some of the initiatives that we've launched. Throughout these few slides that I want to show you, I will talk about some of the initiatives that we have created for SMEs and to help SMEs. And while the slides mainly focus on SMEs who are implementers of standards and standardized technologies, I don't want the notion that there are a lot of SMEs who actually operate as innovators and develop technologies that then become part of a standard. I don't want that notion to be lost in the conversation, and I'm sure that we will have the opportunity to talk about that as well. Before I go into some of the initiatives, I want to briefly talk about what I mean by SME. And you'll see here we use the EU definition of an SME, which employs less than 250 persons and has an annual turnover of less than 50 million or a balance sheet of 43 million. All our initiatives are global, are worldwide. We don't focus only on European SMEs, but we do use the EU definition to define who is an SME and who is not, simply because it's a widely accepted definition that is used well beyond the European borders. So with that, let me talk a little bit about some of the data around the use of alternative dispute resolution. And I want to talk a little bit about that data because one of our initiatives that I'll show you is centers around mediation. So a little bit of statistics of how often we use arbitration. We offer it quite often. And in fact, in the past few years, the statistics that I was able to collect, we've offered it about 70 times. And generally through the WIPO Arbitration and Mediation Center. And as you can see, the response has been lukewarm at best. Has only been accepted once, and basically half of the time that we propose ADR, we hear absolutely no response on the other end. So one might wonder why then focusing on ADR and on mediation in some of our initiatives. Let me go one step further, because we looked at the data and we looked at how many times ADR was offered to SMEs. And we did a bit of a smell test. Obviously, it's very difficult to figure out if a company is truly an SME under the definition if I gave you before or not, but we made a little bit of a guessing exercise to see how many of the 70 companies that were contacted were potentially SMEs. And it turns out that 13 are likely SMEs. And the statistics doesn't change very much. The responses were lukewarm. 8 times we heard nothing. All the other times the offer was declined. So again, why then is ADR something that we want to continue using, proposing, and have an initiative around it? Well, there is hope because if we look carefully at the data, then we found out that 2 of the licensees that declined our offer to use ADR eventually started talking to us, and we eventually concluded the license. So not entirely useless from that point, not all negative, the data that we've collected. Now, this is This is before I move to the next slide. I want to comment a little bit about what is the reason for this lack of responsiveness. And although I don't know the exact reason of each and every company that we've contacted, there's certainly in some cases there could be a lack of willingness to enter into ADR because there is really no interest in entering into a licensing discussion. But in some cases, especially when SMEs are concerned, there could also be a lack of awareness. And so I do hope that initiatives like this by 4IP and others will help promote some of the initiatives that we put in place to help SMEs navigate the licensing ecosystem. So let me go into a little bit more details of some of these initiatives to give you a flavor of what we have done. We've started with a mediation pledge for IoT SMEs at WIPO. I mentioned that, again, ADR had lukewarm response, but I do see it as a useful, I still see it as a useful tool. And in particular, I personally like mediation for a couple of reasons, because it sort of settle expectations for both the licensor and the licensee. Sometimes those expectations may be far apart and not entirely reasonable. Mediation is a good tool to help close that gap and give a more realistic expectation to both sides. But when it comes to SMEs in particular, SMEs who might have less information or be less sophisticated, oftentimes what an SME wants to know is the fact that the offer that I've been giving is comparable to the deal that other competitors, in particular the larger competitors, have got. And mediation is a good tool to provide that peace of mind, because an expert mediator could look at comparable agreements under the confidentiality rules and umbrella of mediation and give an SME a yay or nay level of comfort. Yes, you're getting a deal that is comparable to what your competitors are getting. And that is, in my mind, one of the main advantages of mediation, especially for SMEs. So we have entered this mediation pledge for our own patents at WIPO, together with some other leading patent owners in the space. And basically what we have pledged to is to offer mediation before we resort to the courts to settle a dispute in a licensing negotiation. Again, to give comfort to an SME that we're not going to go straight to the court, but first there's going to be an offer to mediation. That's the first initiative that we put in place. The second initiative that we put in place, and that I will go into much more details in a second, is a IoT SME fund. We have a cellular IoT program, and as part of that program, we've set up this fund, which is fully funded by Sisvel at this point, to help SMEs come in and test the technology. And what I mean by test the technology, oftentimes an SME wants to see if a specific technology works for their products, works in their ecosystem. And so we're providing SMEs the possibility to do that with a license fully paid by Sisvel for up to 2 years and up to 2,000 SME devices. So again, an SME can come in, get fully licensed, test the technology, see if it works, and if it works for them after 2 years or after they cross a threshold of number of products, then they can take a license like everybody else. But before they get to that point, they can make use of this fund. As I said, I will give you a little bit more details about how this fund has been functioning so far. The third initiative that I want to flag are educational resources that we routinely publish. So if you go on our website, we have a wealth of information, including newsletters that you can subscribe to. And we routinely publish, and my colleagues do routinely publish articles to specifically help the ecosystem and potential licensees navigate the ecosystem and the offering. I'm linking here, and I believe that the slides will be shared. I'm linking here one example of one article that was published by 2 of my colleagues, talking about indemnification and how relying too much on indemnification by your suppliers may actually not be the wisest idea. That's particularly important for SMEs. If you have indemnification clauses in your contract with your suppliers, well, those clauses actually might not cover SCP licenses. And so it's probably better off to figure out what your SCP exposure is and how to cover that exposure yourself. As I said, this slide will be shared. A further initiative that we have along these lines is to basically streamline licensing frameworks to enable SMEs to access technologies through licensed model manufacturers. We have recently announced a third model manufacturer license for our IoT program, which basically now gives any company that sources from these three licensed manufacturers the opportunity to include IoT technologies and be fully licensed. That's, again, another tool that an SME can use to make sure that they are, in fact, fully compliant. And the last initiative that I'm going to flag is another initiative with WIPO, which is not specific for SMEs, but goes in the direction of enhancing transparency, is the integration in patent scope of our list of patents that have been evaluated by a third party. We routinely publish sample lists on our website. Those lists are now also available through the patent database at WIPO. So going back to the IoT SME Fund, I want to give you a little bit of the history of what happened in the past few months. So it was launched relatively recently at the end of last year, and we've promoted it quite aggressively in events like Mobile World Congress or other fairs. We have identified about 90 SMEs that are potential prospects, and we've started contacting all of them. And I have to admit, the response has been rather successful. We got 10 companies that have expressed interest. We have an outgoing outreach, especially with Spanish SMEs, because there is a specific technology that has been mandated in Spain, and many of the companies involved in developing those products are, in fact, SMEs, and they use Narrowband IoT, excuse me, which is one of the technologies covered on our cellular IoT pool. And I'm happy to share with you that we have, a few weeks ago, signed our first license with an SME through this initiative. This is quite substantial because it was not even 3 months from the launch of the initiative. To me, this signals two very important points: that industry solutions can address market needs very quickly and certainly faster than any regulation. And in fact, the second point, that even if the best regulation ever could be passed tomorrow, it will not come into effect for many, many years. And we will likely fragment a global ecosystem because it will be potentially regulation in only one jurisdiction. So this to say that, favoring industry solutions when they work, when they try to address market need, is probably the best way to address an ever-changing and growing ecosystem. I'll stop here and I'll pass the ball to the next speaker.
Thank you, Matteo. So, Justine, the floor is yours.
Thank you. Thank you very much, Axel and the whole 4IP Council for the invitation. Jamie and Matteo just mentioned how ADR is one of the topics of interest, both for the UK IPO and for Sisvel. I'll try to dive in a bit deeper. And I will start with just some information about the WIPO Arbitration and Mediation Center for those who are not familiar with us. So we're part of WIPO, the UN Agency for Intellectual Property, and our role is to resolve or to help resolve commercial disputes involving IP and technology through alternative dispute resolution, so outside of court litigation. We're based in Geneva. We have offices in Singapore and China, and we serve users globally. One of our key features is our neutrality. So because we're part of the UN system, we're not tied to a national jurisdiction, which is often seen as a key advantage for parties in an international dispute, because then no one has a home court advantage over the other. Another important point is that we are specialized in IP and technology, which means that we can propose mediators, arbitrators, and experts that have specific technical and industry expertise, including in relation to SEPs. Over half of the parties in our cases are SMEs or individuals. This is true both on the requesting side, but also on the defendant side. And we offer a series of services, including mediation and arbitration. But today I'll focus on mediation because we see that it's really the most frequently used ADR mechanism for SMEs, no matter the type of IP dispute that they're involved in. So what is mediation? It's an informal consensual process in which a neutral intermediary, the mediator, will assist the parties in reaching a settlement of their dispute that is based on the parties' respective interests. So the mediator is not a judge. They cannot impose a decision. Their role is rather to facilitate discussions, to help overcome deadlocks, and to guide the parties toward the solutions. Because of this, the outcomes in mediation are often more business-oriented than purely legal, which is particularly useful in licensing disputes where the goal is really for the license to be concluded. Mediation can also be used not only in the context of a dispute, but also to support difficult negotiations. So, for example, parties could ask a mediator for help to conclude a license agreement and to agree on front rates. This is what we call deal mediation, and we see it increasingly often. Mediation also leaves open court or arbitration options. So if it doesn't work out, you don't lose any rights, and then you can move on to another more adversarial procedure. So why would you consider mediation instead of court litigation for SEP disputes in particular, but also IP disputes in general? Matteo mentioned a lukewarm experience from Sisvel. We agree that I think it's in part due to the lack of awareness about the benefits of mediation. It's a bit scary maybe when you don't know what it is and you don't know how whatever you share within the mediation will be used against you later on. So I'm just going to spend a bit of time explaining the benefits of mediation as we've seen them now over the past 30 years of the WIPO Center's experience. So because many IP disputes often arise in the context of ongoing commercial relationships, for example, licensing, cross-licensing, well, mediation will really help preserve these relationships. At WIPO, we see that around 70% of mediations result in settlement, which is, I think, quite a universal rate also with the other mediation institutions. Second, mediation allows parties to address global disputes in just one single procedure. So instead of having parallel litigation in multiple countries about the same IP rights with potentially inconsistent outcomes in each country, parties can agree to just, settle everything in one procedure, find one global solution that will apply worldwide. Mediation is very flexible. Parties can decide to focus only on some key issues, royalty rates, scope of license, for example, without having to litigate every aspect. So you can really tailor the procedure to your needs. Parties can also select a mediator with the right expertise, whether it's technical, legal, industry knowledge, which is obviously something you cannot do with a judge. You can also choose to appoint a bilingual mediator if parties do not speak the same language. And of course, all of these advantages allow for better efficiency and help parties control the time and the cost of the procedure. We see that mediation is also increasingly supported by courts. So even if litigation is ongoing, courts will often encourage mediation. They can suspend the procedures to allow parties to explore settlement. And as I mentioned, you can always go back to the court case later if it doesn't work. And then another major benefit of mediation for SEP disputes, it was mentioned briefly, is that mediation is confidential. So the WIPO mediation rules in particular offer a very high level of protection, notably concerning the sharing of information about comparable licenses. Now, to give you a bit of overview of our caseload in the area of SEPs and FRAND disputes, so far we have administered over 95 of these disputes, mediations in recent years. We see all types of parties, so SEP holders, implementers, patent pools. They come from more than 20 jurisdictions across the world. We see global players, we see SMEs. It's very varied. Many of these cases are initiated alongside ongoing court proceedings, so it really shows that mediation can complement litigation. We also see a lot of deal mediation in this area. Parties really appreciate having assistance to conclude a license or cross licenses. We have set up a dedicated list of SEP mediators that are ready to assist. We also make available other tailored resources on our website, and we're working on a series of outreach initiatives with some IP offices, including the UK IPO. Matteo mentioned the pledge, so I won't go back on that, but just to say that so far, 6 large players have signed this pledge, including Sisvel. We hope more will join. We think it's a really good opportunity for IoT SMEs to access mediation. We use the same definition as the EU definition to determine what is an SME. The SCP holders also under that pledge offer to cover 2/3 of the mediation costs instead of sharing equally, as is usually the case. And of course, parties can work together with the mediator to address any confidentiality obligations. Another practical tool that I think is very useful for SMEs that are involved in a dispute is the unilateral request for WIPO mediation. So if, for example, licensing discussions are not progressing, or if a party is facing infringement of IP rights, anything really that you're not able to settle directly through negotiation, and you don't have a mediation clause in a contract, or it's a non-contractual dispute, well, one party can submit this simple request through the WIPO Center to basically invite the other party to consider mediation. Once we receive it, we contact the other party, we explain the process, and we will answer their questions to help them decide whether they want to participate. Of course, mediation is voluntary, so we cannot force anyone, but in practice, we see that it sometimes works to have a neutral institution like us reaching out. It can encourage engagement, and even if it does not always work, as Matteo mentioned, you don't really have anything to lose by trying it because it's free of charge. So either the other party agrees and then you move on to mediation, or it doesn't work out and then you can move on to other options. Sometimes we see that also just filing the request will sort of help restart private negotiations. Sometimes it can also be used as a sort of strategic move to demonstrate that one party was willing to settle the dispute out of court. So I think it's worth having a look at this tool. And then I'll conclude with a success story. It was a case that involved a large international Asian telecommunications company as the patent holder and the European SME, who was a consumer electronics manufacturer on the implementer side. They were involved in court proceedings that were pending in various jurisdictions, and the dispute centered around the negotiation of licensing terms for SEPs that were related to wireless communication technologies that were used in the implementer's smart home products. And one of the key issues was whether the proposed royalty rates complied with FRAND obligations. And at some point during the pending court dispute, the parties jointly agreed to suspend the proceedings and refer the matter to WIPO mediation. We helped them appoint a mediator with experience in the telecom sector. The process including written submissions, virtual meetings, a one-day in-person session, and within 6 months, the parties reached a settlement and concluded a license agreement, allowing them to withdraw all ongoing litigation. So it's just one example of what mediation can do in practice. And I will stop here, but of course, I'm happy to take any question.
Thank you so much for the explanation. Let's see if Jamie, okay, Jamie's back too. Okay, so I have a list of questions that I've received, and we have 20 minutes to try to answer most of them, or as many as possible. But first, I've been working with SMEs for years, and especially in standardization. So in your experience, what is the role of SMEs in technology and standards development? I'm not sure if one of you can shed some light on this. And what can we do to help those innovative SMEs, actually?
I can take a stab at the first part of your question, at least. I think we never need to lose focus of the fact that SMEs work on both ends of the standardization ecosystems. There are SMEs that implement standards, but then there are also SMEs that are very active in developing technologies and innovating in the standard ecosystem. And we need to focus on both. There are big opportunities in standardization for SMEs. It is a costly endeavor. And so any help that can be provided to SMEs should also focus on what help different jurisdictions could provide to the SMEs that are involved in R&D. From our end, from the Sisvel end, we do help some smaller companies that have been very active in developing standardized technologies. And more than any other companies, they're very, very good at what they do. They're very, very good at doing R&D, but they're not very good at doing licensing, right? And they need support on that front, and that's what we generally provide.
That's something, you know, I believe that what you have explained, all of you, shows that there are some options that the SMEs are able to use. The issue is they might not be aware of those options, and that's part of this education, you know, activity that we are doing. When I look at the now withdrawn Commission, the European Commission draft SEP regulation, as well as all the work done by the UK IPOs, like the recent SEP consultation that you have done. I think they were motivated, at least partially, by the intent to help SMEs. What is the role for regulation, in your view?
I can segue to what I was saying before. I think we should really focus on both ends of the equation. I'm not going to speak for the UK IPO. Jamie can do that. I think the SEP Hub is a great resource for SME. One of my main criticism to the now defunct SEP regulation by the Commission was, in general, the fact that they were focusing primarily on standards implementation and not at all on standards development. I mean, we live in a world where you take the biggest technology developers in the world, they're competing fiercely on leadership in the standards development. And the Commission took a view that instead Europe was focusing only on the implementation of standards, which in my view was short-sighted. That's what I would say. I mean, any regulation that tries to help SMEs should really recognize that there are SMEs that do both, that implement standards, and then there are SMEs that develop standards.
Jamie, a question that is recurring is, when following all the work that the UK IPO has done, when do you intend to move forward? Do you have any proposals you have identified, you have consulted? What's the next step for you?
Thanks, Axel. So just picking up on a few other points as well, the role of SMEs in standardization. And I think, Matteo, you pick up some really good points here, and you made some really helpful observations, because I don't disagree with the aspects around looking at the both ends of the spectrum. You know, we also recognize that there are some really innovative SMEs who operate in the standardization space, and we see it in the video codec area, for instance, in the UK. We've got some really innovative companies who operate in that space, and I think, you know, part of our objective is to ensure that we can future-proof. We can look at the kind of, you know, we have an incumbent set of innovators, but how do we bring new innovators into the space? And the UK, the demographics of the UK and how industry is represented in the UK, the majority of the UK businesses are SMEs, and we can't ignore that fact. So we do have to think about, actually, you know, it's about supporting those SMEs who want to innovate and use their IP effectively to innovate in technical standardization, but also those who are innovating on technical standards, not necessarily using the IP end of things as well. We have to recognize there is a role for everybody. I think I would go one step a bit further as well than what Matteo said, that we also recognize there's very large businesses who are incumbent in the standardization space who also can and do support SMEs, and perhaps could do it better as well. And it's about making sure that there is a diversity in particular technology areas where, you know, smaller businesses are encouraged and supported and given the opportunity, like the incumbent businesses as well. So I think there is another dynamic to this as well, which I think we need to also bear in mind. Role of regulation, I would say, again, this is a tricky area for the UK at the moment, because we're in the process of considering what we should do, what we can do, what we should do, and what we shouldn't necessarily touch. I think regulation is quite a sort of a strong proposition to make. At the end of it, we've got to look sensibly across how the market operates. There are market solutions. Some market solutions are effective, others aren't, and they need time to develop, of course. And that's something which we are also acutely aware of, that the whole standardization, technical standards, IoT is a dynamic industry, and it's developing, and we've seen some incredible innovative tools and business opportunities which have come into the market and provide very effective and accessible services. But regulation sometimes is needed when things can't be fixed and continue to be broken. So we need to be very mindful that we need to be careful and really considered about whether there is a role to regulate in this area. And in terms of what we're doing in the UK, as some won't recognise what we've been doing, but we have consulted on a number of areas around looking at how you can get a bit more predictability around the rate and the methodologies, and ways to get a price set for licensing. We've also looked at how the information asymmetry can be considered, and how we could help alleviate some of the transparency issues around SEP licensing. And what we've done, we've consulted on 6 particular areas, including areas around better understanding essentiality, or pools use, or use of pools in these technology areas. Thinking of Matteo as well, really informing ourselves, I think, through this exercise around the important role that pools and pool administrators can play for certain technology areas. But we are still reviewing and deciding what we can do with the evidence. There's been an awful lot of evidence which the UK has received, very technical, detail, often quite polarized views. We recognised that back in 2022 when we consulted first time about the landscape. But also we've received some really interesting, challenging ideas which we hadn't anticipated before. So I think we now have a fresh set of evidence. We are considering what can and can't happen, really. Again, it's going to be how we put some of these matters to ministers. Ministers will have to make the decisions. It's not for the policy people to make it's the ministers who will have to decide ultimately on these matters. But I think I would just say, really, Axel, on your question, when, because that's the key thing. When are we going to make a move? Patience, really, with that. I think it's imminent. We are getting there. Hopefully this side of the year, we will have something where we can communicate out. I'm not going to hold myself to that in a sense in that timeline, but there's always things which we have to navigate around, and even going through clearance processes, engaging ministers. Minister will want to engage with industry as well. That can add time to our consultation process as well. So with the best wind and the best will in the world, we'll hopefully get something imminently back out to industry to review, and hopefully it will be seen as a modest and sensible approach to the issues.
Okay, but based on what Justine explained earlier, it seems that solutions already exist, and it seems to be working quite well. But you noted something, Justine, that is about confidentiality, and you said that it is an advantage of ADR for SCP licensing disputes, and that the WIPO rules include some strong confidentiality provisions. How are these confidentiality principles applied in practice?
Yeah, thank you for the question. I think confidentiality is really a main concern of parties involved in SEP disputes. So the first level is that under the WIPO rules, confidentiality applies at several levels. So the existence of the mediation, the submissions, and anything that is said during the process, everything is confidential unless the parties agree otherwise. So parties can share sensitive information without the risk that it will be disclosed or used outside of the mediation. The mediator is also bound by these confidentiality obligations, so the mediator cannot use that information. This being said, there's a quote that says you can't put the toothpaste back into a tube. So once you've shared some confidential information with the other side, the simple fact that they have learned this information can sometimes be problematic. So the parties also have the possibility to agree on additional safeguards. And this is something we see often in like the friend negotiation area. For example, you can limit access to specific representatives. You can say, this information is shared only with the council, but not with the parties. Attorneys can review the documentation in person, but cannot make any copy of it. In very extreme cases, parties could also agree that only the mediator will see the documents and then will prepare some form of, aggregated report where there's no specific data on one specific license. So everything is possible, really. The parties can really shape the process so that they feel comfortable negotiating and trying to find a solution without worrying that they're actually sharing information that is confidential to them. So yeah, there's a bunch of options that are available, and these are just some examples that we've seen so far in our cases.
A quick follow-up for you, Justine. How long does an SAP dispute mediation usually take?
Well, in general, a mediation will take a couple of months. Our average at the WIPO Center is 3 to 4 months. Some of them take a bit longer. In the example I gave, I think it was 6 months. It depends, but it's a matter of months, usually, not years. So yeah, it will depend, of course, on the complexity of the dispute, the types of questions that need to be negotiated. Sometimes it's just a question of availability on both sides. Sometimes also the parties they have a first session, then they need to take a break so that they can look at things separately and come back with some proposals based on preparation that they will have done after the first meeting. So based on all these elements, it can vary a bit, but yeah, I would say in general about 4 months from start to finish.
Actually, if I can jump in to put that into perspective, sometimes it takes 9 or 12 months to negotiate an NDA. So.
It was my following question, actually, because if it takes between 2 and 6 months for the mediation, because it started because there is a disagreement, right? But Matteo, in your experience, what's the percentage of cases where a mediation or a disagreement happens? I mean, I understand that most of the negotiations happen without a disagreement at the end. They agree on something and they move forward. So just to have an idea, what's the percentage of cases that requires to go to court, and what's the percentage of cases that requires to go to mediation in your experience?
I don't want to give specific numbers because I don't have specific numbers and I would need more statistics. What I can say is the following: the vast majority of licensing negotiations do end up in a license being granted and being taken without the use of litigation. Now, of course, things change when the exposure is relatively large, right? That makes things a little bit more adversarial sometimes, and so that's maybe harder to get to a solution. But I think the main concern that I have is if you go back to the data that I shared about the unresponsiveness and the percentage of parties that just don't respond to the proposal to use ADR, or in general don't respond to licensing demands. I think that's the most concerning part of licensing negotiation in the SCP space. And let me be more clear. I think when there is a pool license, for example, a pool that has achieved critical mass both in terms of licensors and licensees, which means that there is a big patent coverage and there is a number of implementers who have taken that license. Those who refuse to take a license or just don't respond, ignore the request, there should be a recognition by the ecosystem and the courts that that behavior is sure holdout and is hurting the ecosystem, because it's hurting not only the licensors, but it's hurting also the licensees who are in fact paying for a license. And there is a very practical aspect to it. Let me give you just an example. Let's assume there is a licensing program that charges $1 per device, and 50% of the market is licensed, while 50% of that market remains unlicensed because it's holding out. Well, my royalty rate now is not $1, de facto is 50 cents, right? And so we would quickly go down a spiral where the rates become lower and lower because there is a percentage of the market who's subsidizing the other, and there is a percentage of the market who's unfairly competing with those manufacturers who do take a license. I know I haven't answered your question in terms of percentages. I want to end in a positive note. Again, most of the licensing disputes that we see end up in a license without the use of litigation, maybe because we start with an ADR request and that triggers a conversation. And so there is certainly a part of the ecosystem that behaves fairly on both ends.
Oh, that's very interesting, because what you are saying applies to most of the time. I mean, it applies to big companies. So for the SMEs, the number is definitely even smaller. And that's quite interesting. But Justine, if you compare the number of cases that the WIPO Arbitration and Mediation Center is taking care of, percentage, because you gave a number regarding SEPs, but overall, the SEP cases represent a very, like a fragment, very small portion, or that's something big?
I don't have specific data on that. What I can say is that we administer all types of disputes, and in our numbers, we also count disputes that we call co-administrations, which are the result of programs that we set up with IP and copyright offices to help them administer their own mediations internally. But if I look at the number of cases that took place under the WIPO rules, I would say that in the past years, SEP disputes are not, they're more than a negligible amount of the total number of cases. It's really an area where we see a lot more interest in mediation, a lot of unilateral requests that are filed. Not all of them lead to mediation, but many of them lead to some form of renewal in the private negotiations. So yeah, I don't have specific numbers to give you, but I would say, yeah, these types of disputes are material in the total number of disputes that we administer every year under the WIPO mediation rules.
That's very interesting. Thank you. I have one last question I just received. So we have the option of using the WIPO Arbitration and Mediation Center, and now, or soon, or currently, there's the PMAC. So if I am an SME and I have a dispute, potentially I have disagreement, why would I pick the WIPO Arbitration and Mediation Center and not the PMAC?
Well, that's a good question. We need to see how the PMAC will evolve. Right now, it's not yet operational, but of course, if you have a dispute that's pending before the UPC or under UPC jurisdiction, it may make sense to use the PMAC. Overall, of course, we are fully international. We can administer all types of disputes, including those that do not relate to European patents. We also have these specific sectors of activities where we really work with stakeholders to develop ADR options that are tailored to their needs. So I think, yeah, we have over 30 years of experience, so we're always happy to help. But of course, I mean, competition is healthy, and we understand that a number of patent disputes may go to the PMAC once it is operational. But I think, yeah, other centers certainly remain relevant in the area of patent disputes more generally, especially when it's not only Europe-based patent.
And before closing, one last question for Jamie. Does the UK IPO offer a fee reduction for SMEs?
Thanks, Axel. We don't. We don't sort of distinguish between SMEs and other businesses. I think our rules are set centrally, and unfortunately, we don't offer SMEs. What I would say, our fees are quite comparatively low, even with the latest fee changes which are coming in April. They're still incredibly competitive and low for applications, etc. So I would say yes, the lowest they are, but we unfortunately don't offer any sort of additional fee reductions for SMEs.
Thank you. But that's still a positive note. It doesn't cost much. SMEs have many options. It seems that I was looking at my notes, and about 96% of licensing negotiations simply end up with an agreement. 96%. So that's quite high. So I can understand that solutions exist, and SMEs have a bright future in licensing. I think that's the time to close this webinar. Thank you very much for sharing your thoughts and showing that there is a lot of education that still needs to be done. Thank you, Jamie, Justine, and Matteo for sharing your experience. And yes, the slides will be made available from tomorrow. Then I would like to invite all of you attending this webinar. If you are interested in street arts, copyright, and AI, we have a webinar for you, which is coming up on May the 28th. That will be looking at the legal challenges at the urban frontier. Then on our website, you will find everything to start learning, research papers, and more. But tomorrow you will receive a short survey to provide your feedback regarding this webinar, as well as making recommendations on the topics that you would like for IP Council to cover in the next webinars. So I would like to thank you again, Justine, Jamie, and Matteo, for attending and sharing your knowledge today, and as well as thanking all the attendees. Thank you and have a great day.